So welcome to class. First thing I'm going to do is share my screen as usual, so we can review where we are. And here it is today, January 19th. Some of you are still working on your first essay and actually submitting your first draft. And you know who you are. Please get that in as soon as you can. You do not really want to be working on 2 essays at a time. The whole idea is to write an essay and then get the feedback and then be able to use that feedback to make the second essay better and the third and so on. And this class really does rapidly come to a close. I realize we just started, but it does end quickly. So tonight, we're actually going to take a look at the content for essay number 2. So we'll look at the Bill of Rights together. And then on Tuesday next week, that's when I'm asking for the first draft of this essay number 2 to be in. I understand some of you are still on essay 1, so there's a little bit of leeway there. If it slips and you can't get it in for a couple of days, that's okay. It's still January, but it's going to be February really soon. And so you need to pick up the pace a little bit so you can actually learn something and do some good writing. Okay, so essay number 1, first draft, is supposed to come in on Tuesday, the 24th. And then the second draft a couple of days later on the 26th. So as you can see, the turnaround is really happening quickly. And you want to stay up with that. I won't show you that now, but if you look ahead, by January 14th, we're really going to be into the final exam, and that's not far from here. It's only 3 weeks. So if you haven't got that essay number 1 in, please do so. Okay, let me stop the share for a moment and see if anybody has any questions about where we are, what we're up to, what we're doing.
Yes. Hello, Professor. Yes, I sent you an email with I started doing my draft number 1. But I would like to know if I'm doing well, because I don't know if I understood well the topic or no. So I can continue to finish my essay, or I mean my draft. So I send you. So please, if you have time, then can you help me with this so I can complete it?
Yes, I actually thought I sent it back to you. I did look at it. I'm checking now. Oh, I see. You sent essay number 2 draft here. Okay, I got it. Yes, I'll look at it. I will look at it.
Okay, Professor, thank you, because I want to be sure before to continue doing it. Thank you.
If I don't do it tonight, I'll do it first thing in the morning, so you'll have it soon.
Thank you, Professor. Thank you very much.
And anybody else, that's it, just to point out, if you do send me something and you don't hear back from me, it's a really good idea to let me know so that we don't lose any time. Occasionally I'll lose track of things, or I'll think I sent something back when I didn't. So please be aware of that and follow up. You're not actually bothering me. Okay, somebody needs the password, so just bear with me for a moment and I will send the password to the student and let them in the class. Okay. Okay, that should do it. She should show up soon. That'll be good. Okay, so if there's no other issues, then let's just get to it. I will share my screen, bring up the class notes again, and let's take a look at the Bill of Rights. So what happened? We read the Declaration of Independence. Of course, that was the announcement that the people living in the 13 colonies were declaring their independence of England, and a war ensued. And of course, England was the most powerful political power, military power on the planet. And nobody really thought that the colonists were going to defeat England in this war, but they did. Everybody was surprised, not the least of which the people who were living in the colonies who actually won their independence. And so they then had to face the task of creating a country, a government that was not from the top down, but that was from the bottom up. They wanted to make sure that the power of the government remained in the hands of the people who were being governed and not the leaders. This is the first time in thousands of years or ever on Earth that people actually were going to form their own government and not be ruled by a king or a queen or a monarch or a warlord or an emperor. And so it's really, they were creating something absolutely brand new. In the Declaration of Independence, we saw the theory of the inalienable rights, which we all talked about. But now the people who won the war, the colonists, founding fathers, we call them, were faced with the task of putting that theory into practice, actually creating a government that protected the rights of the people and did these other things. And so they definitely took a look at the theory and said, wait a minute, we can't just have a democracy. A democracy, which is a Greek word, means mob rule. A mob rule is just as bad as when a king is ruling, the tyranny of the majority. Mob rule means majority rule. And majority rule, it can be tyrannical, just like the tyranny of the king, because minorities don't have any rights when the majority rules. And so they wanted to make sure when they created this government that they had minority rights protected. So they created what we call a democratic republic, a representative democracy. And they designed a constitution, a blueprint for the government that protected minority rights. Wanted to make sure that people could hold on to their rights and that the government would be limited and not be able to be tyrannical and control everybody's lives. For example, some of the states, there are 13 colonies, some of them were larger like New York and Pennsylvania, and some of them were smaller like Rhode Island and Connecticut. And clearly the larger states could have more population and the smaller states less population. So if you just went on the vote of the majority, those bigger states would certainly have more say in the government and the little states would have less say in the government. And so this is one of the kinds of things that they needed to try to balance out. The people in the different states had different beliefs, different religions, different ideas about what to do. And so those states, those little colonies that turned into states, wanted to remain as independent as possible, but at the same time, get together and form a nation. So they structured the American government in such a way, the new government in such a way in the Constitution, to limit the power of the government as much as they could. And one of the ways they did that is they divided the government up into three different parts. We call them branches, three different branches of government. And each of those parts had equal share in the power of the government. Of course, under the king or under the queen or the emperor, all the power was in the hands of one person. Here, they were trying to make sure that didn't happen. So they would have different people occupying the different offices in the different parts of the government. And they were hoping that that would diffuse the power and make it harder for the government to become tyrannical and rule everybody's lives. And this divided these three branches divided the power. And so we have the first branch, which is the Congress. We know the Congress, that's the legislative branch. And what the Congress is responsible for is creating the law. That's all they do. They don't enforce the law. They don't punish anybody. They just create the law. And they created a Congress with two different parts. One we call the Senate, and for each state, they gave 2 senators. And the other part they call the House of Representatives, and this one was based on population. So this is one of the ways that they balanced the large states and the small states. every state had 2 senators, so the small states would have 2 senators and the big states would have 2 senators. They'd be equal in that house, in the Senate. And in the House of Representatives, since it was based on population, okay, the larger states would have a little bit more say, but still the Senate and the House, these 2 bodies, would have to work together in order to pass the laws, so there would have to be some negotiation. And that's one of the ways that they limited the power of the government. Then they created the executive branch of government, the president, which is the branch of government that carries out the law, that enforces the law. To execute means to do something. You might think execute means to kill somebody, but really execute means to do something. And this is the branch of government under the president where everything gets done, where the law is actually carried out. So the military and all the different departments of the government, the Department of Transportation, the Department of Commerce, the Department of Education, Health and Welfare, all the different people who work for the government and actually do things work for the executive branch, obviously a very powerful branch, but they can only do action according to the law, and the law is created by the Congress. The president has a say in that, but if the Congress gets their act together, they can override any objections of the president. President can object to a law, we call that a veto, but the Congress, if enough senators and enough representatives get together, they can pass a law even if the president disagrees with it. So that makes very, very good division of power here. And then the third part of the government is the Supreme Court, and the Supreme Court's job is to make sure that any laws that Congress makes and the president agrees to, that any of those laws are in accordance with what the Constitution says. So in essence, they're the protectors of the Constitution. So Congress makes the law, the president carries out the law, and the Supreme Court judges the law to make sure the law is legal, basically. So the Founding Fathers created this form of government. Actually, the Constitution is a document that's not that long. It's only 12 or so pages. It's not very complicated. And they were hoping that this structure that they created would allow for a government that protected the rights of the people. And then they realized that they had left out the idea of the rights of the people. And so they added these first 10 amendments, first 10 additions to the Constitution, and they bundled it together so that everybody would receive all of this information at the same time and vote on accepting it at the same time, because all of the people in the different 13 colonies had to vote to accept, to ratify, to accept, to approve the Constitution itself, which they did. So the Bill of Rights spells out the rights of the people, the civil rights of the people, the rights under the law of the people. And it comprises the first 10 amendments to the Constitution. There have been more amendments to the Constitution since then, but these first 10 amendments came along with the original Constitution called the Bill of Rights. Here's the citation you can use in your essay and your works cited. So you can just copy that. Actually, that should be double spaced. I know I keep telling you that, and then I don't do it. So for sure, you can just copy this and use this. You notice I have an access date that's older. You can put a different date on there if you want. The person who's chiefly responsible for writing the Bill of Rights, the different amendments, it was named James Madison. He wound up being our 5th president, I think, 5th. So sometimes people think of James Madison as the author of the Bill of Rights. And then I put in here some background information for you to look at. We won't read that together now, but certainly it's there for you to look at and to help you think about what you want to write. But let's look at the amendments themselves. First Amendment, which some of you may be familiar with, is very important, and the Founding Fathers put many of the civil rights into this First Amendment. But all of the amendments that are there actually give some limitation to what the government can do and provide rights for the people. This is just really the most famous one. Let's take a look. Congress shall make no law respecting an establishment of religion. So you can see right there, what they're doing is they're limiting the power of government. They're saying Congress cannot make any law with regard to what they call the establishment of religion. Established religion is a term used for the religion of the king or the queen or the emperor. In Europe, where most of these people ran away from, in Europe, the king would have an established religion for the nation, such as England was Anglican, and the official religion of the country was Anglican. In France, the king was was Catholic, so the established religion of France would be Catholicism. In Spain, it was similar. The established religion was Catholicism. And I realize they're all Christian, but the Christians, the Protestants and the Catholics had been having bloody wars and killing each other for 200 or 300 years since 1517 throughout Europe. This is now 200 years, 250 years later. And a lot of the people who came to populate the colonies here in North America were fleeing religious persecution. People from France who were Protestant were fleeing persecution from Catholics in France. Many of them went to Canada. And people in the other areas were leaving. Catholics from England would come to the colonies to get away from the Anglican Church in England, like that. So the idea here that they put forth was that the government, the new government that they were creating, would not be able to say that there's an official religion in the United States. We call this separation of church and state. Church being, church representing religion and the state representing government. So the first really freedom, civil right that's here in the First Amendment is this separation of church and state. Then it says, Congress shall make no law prohibiting the free exercise thereof, meaning the free exercise of religion. So the second freedom that's in the First Amendment is freedom of religion. So there's two things related to religion. One is that the government cannot establish a certain religion for everybody to follow, and that every individual living here in the United States can choose what kind of religion they want to follow, and laws cannot be passed to stop them from doing that. So here, Congress shall make no law abridging the freedom of speech. To abridge means to limit something, to shorten it, to limit it. So no laws can be passed restricting freedom of speech. And over time, the Supreme Court has ruled that speech is not just speaking, but speech is really any form of expression. So music, so art, movies, books, anything that is a creative expression of an individual or a group of individuals is really covered under freedom of speech. One of the reasons pornography is legal is because the Supreme Court ruled that pornography is freedom of expression and falls under the constitutional guidelines of freedom of speech, and therefore the government can't limit that, can't prohibit that from happening. You may be in favor of that or not, but that's why there is pornography around. So here, Congress shall make no law abridging the press, the freedom of the press. And here, the press really, they're talking about news and reporters, but they're also talking about any printing press, because the printing press was, so books and other things would be covered here too. But basically the news, this is the news, and this is really important. Thomas Jefferson, who was our second president, was very concerned about the fact that since people were voting, people needed to have information. They needed to know about circumstances of what was going on in the world so that they could make an informed decision about what to vote about. And so freedom of the press was very important. Congress shall make no law prohibiting the right of the people to peaceably to assemble. That's very important. You probably think of that as protesting, like all the people who protest in the streets, and that's true. Of course, they're supposed to protest peaceably, not with violence. If there's any violence, then the government can act to limit that. But really, this right of assembly means people can get together join together for any purpose at all. You want to have a bridge club, you want to have a parent club, you want to start a business, you want to have a nonprofit, you want to make a golf club, whatever you want to do, you can do, and the government can't prevent people from joining together and doing things and creating things and living life. So it's not just assembling in the street. It's not just getting together in the street and protesting. It's really getting together and acting in any way, very broad. And then lastly, the Congress shall make no law abridging the ability to petition the government for a redress of grievances. To petition simply means to ask, and a grievance is a complaint, and redress is to address it, to solve that complaint, to do something about it. And this means that you can ask the government to change what it's doing, or tell the government to do something differently or something new, and the government can't do anything against you. Government can't take action against someone, the squeaky wheel, who's complaining about this problem that the government keeps happening. Of course, under the king, if you criticize what the king was doing, the king could just throw you in jail. So the whole idea here was that people should be able to criticize the government and not have the government come after them, right? These days, people talk about weaponizing the FBI or weaponizing the Internal Revenue Service, and that would be the kind of thing that this right was trying to prevent the government from coming after people who complained about things, because of course the king did that all the time. So here we have in the First Amendment 6 different freedoms. You can see them there. You could stop right now. We won't. We're going to look at all 10 amendments, but right now for your essay, you can simply choose any 3 of these. And of course, I say 3, so you have a 5-paragraph essay, and you can get to the 500 or 600 words rather easily. And don't forget, for the second essay, you need 2 outside sources that you find on your own from your research. For the first essay, it was just 1, so 2. So you can choose any 3 of these. You could choose freedom of religion, freedom of speech, freedom of the press, and simply write your essay about those 3 freedoms if you wanted to. Or we'll go through the other amendments, and you'll see there are other freedoms in the other amendments. And really what you can do for this essay is you can mix and match. So some of these amendments, some of the parts of the amendments, as you can see, the amendment has many parts, and you only need to pick one part. So you could pick a part from Amendment 1 and another part from Amendment 4 and another part from Amendment 5. As long as you have those 3 paragraphs in your essay, that's okay. So let's go through the Bill of Rights together, and you can hear the different amendments and see what things are important to you, what things are of interest to you. Because if you have to do some research, you have to do some writing, and you have to do some thinking, might as well choose things that you're interested in. So there we go. Here's Amendment 2. A well-regulated militia being necessary for the security of a free state, the right of the people to keep and bear arms shall not be infringed. Infringed means limited. So here, this part is pretty clear. Bear arms. Arms are weapons, guns these days. We usually think about weapons as guns. The reason for this amendment, the chief reason for this amendment, was that the colonists had just fought a war against England, and the people who fought in the war had taken their muskets that they had in their home and brought them down to where the army was and joined the army. So the founding fathers were very cognizant. They recognized the fact that the citizens of the United States needed to be able to protect the United States from any foreign enemy. And they were very afraid that France or Spain or even England would come back to the North America and try to colonize them, try to enslave them again. So they wanted to make sure that people had weapons, so in case that happened, they could fight against whoever may come. And guess what? They did come. This was 1789 when this was written. In 1812, 20 some odd years later, England invaded the United States, the War of 1812, and England tried to retake all of these colonies in the War of 1812, which the United States managed to fight England off again. But nevertheless, that's the reason that they wanted to make sure that the citizens would have guns. Also, in places like Europe, even today, where guns are banned, the people don't have any way of resisting the government. If the government turned tyrannical, what could the people do? The government has all the guns. So the founders wanted to make sure that if this government the country that they created no longer was secure as a free state, if the government turned tyrannical, that the people had weapons to protect themselves and could fight against the government. So there's that idea too. Meanwhile, here, a well-regulated militia. A militia is a citizen army. And over time, the Supreme Court has ruled that the militia really refers to these days the National Guard. Maybe you've heard of the National Guard. National Guard is when citizens like you and I, on the weekend or a couple of months a year, go into military service. It's all organized by the different states, and you learn all those military skills, and you learn how to fight and how to use the weapons. So the National Guard is also called out in emergencies. You might know if there's a hurricane, a tornado or something, the National Guard is often called out in order to help people. And then people who are in the National Guard, who might be a grocer or a lawyer or a car salesman, need to leave their jobs and respond to the call that the state has made. But really, this entire Amendment 2, Second Amendment, deals with the ability of people to own guns. And that's a very controversial topic. You may think it's a good idea, you may think it's a bad idea, you may have been affected by people having guns, you might have a lot to say about that. So when I said, oh, sure, you can choose any of three of these and write about it, but here's a very interesting topic also that you could write about, gun control. And this part says very clearly that you can't control people's ability to have weapons. And this part says the Supreme Court has interpreted, well, maybe that's the National Guard and not individual citizens. So there's really a lot of tension in this amendment too. We thought of different ways. Some of these amendments are really short. Some of them are a little longer, a little bit more complicated. Here's Amendment 3. And this really has to do with the fact that the King of England, during the war, would have his soldiers live in the people's houses and eat the people's food. And so the citizens of the United States didn't want that to happen anymore. That was a terrible thing that they experienced. No soldier shall, in time of peace, be quartered in any house, meaning sleep there and eat there, without the consent of the owner. Of course, the British just came right in. Nor in time of war, except by a manner to be prescribed by law. So they recognize that wartime is a different time, but basically can't just stick soldiers in people's houses like the king was doing. Very restricted amendment, very, very specific. But here's Amendment 4. Look at this one. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. This is the closest thing, shall not be violated. This is the closest thing to a right to privacy that we have. We don't actually say privacy, but persons, houses, papers, effects, those things are basically our private property. And so the government cannot search your property and take your things without probable cause. They can't have a warrant. The judge can't issue a warrant and say this person should be arrested or these things should be taken, except on probable cause. Probable cause means the government has to be able to prove that there's a reason that they need to enter your house and take your stuff. And that means that the police, in this case, right, the police, who are part of the executive branch, the ones who carry out the law, would have to go to a judge, which is part of the judicial branch, and convince the other branch of government that this is a necessary thing to do. So by dividing the power between the executive and the judiciary, the founders had hoped that it would slow down the process of the government just taking what it wanted and invading someone's home and arresting them and seizing their stuff. And that probable cause has to be supported by oath or affirmation. So there needs to be a witness. Somebody needs to say, oh, I saw drugs in that person's house. And then the police could take that statement, go to the judge, get a warrant, go to that house, seize the drugs. and particularly describing the place to be searched and the persons or things to be seized. So the government can't just come into your home and take whatever they want. In advance, they have to say, we're going to have a search warrant. They're going to come into your house and say they're looking for drugs and find drugs, illegal drugs. And they can do that if they have the search warrant. But if they see a gun there, they can't seize the gun because it's not part of the search warrant. They would have to go back to the judge, get another search warrant for guns, and come back to your house in order to do that. Of course, the king always sent his soldiers and his marshals into people's homes, and they could take whatever they want, throw the people out, arrest them. So this, again, was an attempt to limit that power of the government, the police power of the government, to invade people's homes, invade people's privacy, and disrupt their lives and arrest them and take their stuff. So that was the whole idea here, to limit the power of the government. Very important amendment, Amendment 4. As you can see, there's a lot of parts to this. So as I was saying before, you could write about one part of this and one part of another amendment and another part of another amendment if those things are interested to you. Sometimes students find different ideas in the different amendments that sort of hang together and express the same train of thought, line of thought, logic. And so they put things together that way. Here's Amendment 5. This is another complicated one, but very important. No person shall be held to answer for a capital or otherwise infamous crime. A capital crime is one that's punishable by death, unless on the presentment of a grand jury. You might know about a regular jury, 12 people or 6 people who sit in judgment in a court case. A grand jury is a little different. Maybe some of you have served on a grand jury. Grand jury is 25 or 30 people, and it's called together by the prosecutor, and there's no defense, there's no defendant there. It's just the prosecutor and all these people. And the prosecutor presents the information to the grand jury that a crime, it's probable that a crime was committed, and it's likely that so-and-so, this person they suspect, committed the crime. And if the prosecutor can convince the grand jury of that, then the grand jury issues an indictment against that person, and then the police can go arrest the person and charge them and try them. Of course, when it comes to the Army or the Navy or the Air Force these days, the military has a totally different system of justice, Uniform Code of Military Justice. And when you're in the military, none of these rights apply to you. You are subject to a totally different set of rules. Here, no person shall be subject to for the same offense to be twice put in jeopardy of life or limb. We call this double jeopardy. If you've tried for a specific crime, somebody says you stole something, take you to court, the jury says, nope, he's innocent, she's innocent. They can't the next day arrest you for the very same crime, throw you in jail and try to try you again. They get one shot, and if they don't prove that you did whatever it is they say you did, they can't put you in jeopardy again. There's no double jeopardy, unless, of course, new evidence comes up. Here, nor shall anybody be compelled in any criminal case to be a witness against himself. So maybe you know about the Miranda rights, where they say you have the right to remain silent. That's where this comes from. This is a constitutional right that you don't need to talk to the police because there's the danger that you might be testifying against yourself. This is also a prohibition against torture. Torture was a common way in which the king and others would try to get people to confess, and even around the world today, there are some places where torture is used to do this. Get people to confess to a crime, because of course, rather than feel the pain, you could just say you did it, that would do that. So this is a prohibition against torturing people in order to get them to admit that they did something. Nor can anyone be deprived of life, liberty, or property without due process of law. Very important, because here we're talking about the process of law. Remember when we talked about liberty, and I talked about how liberty is freedom under the law, that's the kind of freedom we have. Well, if due process means that the police have to follow the right procedures in order to enforce the law. They can't do whatever they want. There are certain ways in which they need to act in order to enforce the law. That's what gives us our freedom under the law. The law says police have to do it this way. If the police don't do it the way they're supposed to, then you're not going to be held liable for whatever they've done. If a chokehold is illegal and the police use a chokehold, they're violating the due process of law, for example. So this is very important. Due process is, the Supreme Court spent a lot of time making sure that the executive branch follows due process and does things the way they're supposed to. Nor can they take private property without paying you for it. They can't just seize your stuff, which of course the king always did. Here's Amendment 6. In criminal prosecutions, you have the right to a speedy and public trial. So they can't just throw you in jail and lock you away and leave you there forever. If you don't come to trial in a reasonable, speedy fashion, then you're going to have to be let free. And the trial has to be public. It can't be a secret trial. Soviet Russia, for example, they always had secret trials. Nobody ever knew what was going on. And in some countries around the world today, they have secret trials. Whereas here in the United States, the trials are public. People can go, they can listen, they can watch, and they can see what's going on. It has to be by an impartial jury. That's the kind of jury you're probably familiar with. The jury needs to be impartial. They can't start out thinking that the defendant is guilty or innocent. They need to have an open mind. That's the way the process is supposed to work. And it needs to be a jury from the area where the crime was committed. They can't just spirit you away to California from New York and try you there where the conditions might be different. You need to be told what it is that you're being charged with, the nature and the cause of the accusation. So if somebody arrests, if you're being arrested and you say, why am I being arrested? They need to tell you why you're being arrested. They can't just arrest you. They need to tell you why you're being arrested. And anybody who's arrested has the right to talk to witnesses and in court and cross-examine them. So that if somebody's testifying and say that person did such and such, you have, as a defendant, you would have the right to say, well, were you really there? Were you somewhere else, right? You can question them and cross-examine them and see if their testimony is correct. And the defendant has a compulsory process for obtaining witnesses in his favor, meaning that the government can subpoena someone and make them show up in court and testify, and so can the defendant. If you're accused of a crime, you have the authority, constitutional authority, with your lawyer to go to the judge, get a subpoena, and force someone to come to court and testify and say what they know or say what they saw, or whatever it may be. So, and lastly, you have the right to the assistance of counsel. So, if you don't have a lawyer, one will be appointed for you, those Miranda rights. That's where this comes from here. So here, the founding fathers were assuring that people who were accused of crime not only had lawyers to defend them, but had the power to bring witnesses, to know exactly why they were being charged with whatever it is, that there would be a public trial, that it would happen quickly, and there would be an impartial jury of their peers, people who lived in that area, to pass judgment on them. Very important, very powerful amendment dealing with criminal prosecutions, protecting the rights of the people against the government. Because in the past, the government could just claim someone was a criminal, throw them in jail, try them in secret, execute them, and that would be the end of that. So this is really important. Okay, here, now this one here is really very specific. This one deals with criminal offenses. This one deals with civil suits. And basically, this is small claims court. Maybe some of you have been to small claims court. Here they're saying $20. Okay, you have a right to trial by jury if the civil suit is over $20. These days, I think it's more like $1,000. They've obviously, with inflation, changed that amount. But the idea here is this is not to clog up the courts with minor offenses. And in this kind of court, the judge decides there's no lawyers or anything. The two sides come in, they argue their case before the judge, and the judge makes the decision, small claims court. And here, very important, excessive bail should not be required. So these days, there's a lot of talk about bail, about cashless bail, about no cash bail. So here it says excessive bail, but that's the basis for which many people are now saying they shouldn't be cash bail. Again, might be something you agree with, that you disagree with, something that affects you in some way, or you know about it. So it's an interesting thing to think about. You can't have excessive fines. That's the idea behind cashless bail, I suppose. And then this one, nor cruel and unusual punishments inflicted. That could be torture, but it could also be, as the Supreme Court has judged, the death penalty. So the reason we don't have the death penalty all over the United States for all kinds of different crimes is because the Supreme Court has ruled that the death penalty is cruel and unusual punishment. And these last two are very important. So I'll do them together. This one basically says, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Enumeration simply means listing. So here in the Constitution, they've listed certain rights, but they can't list all of them. They knew they couldn't list all the rights that people have. So basically they're saying people have other rights that are not included here. Think of the fact that there's a lot of controversy about our right to abortion, for example. Well, there's no right to abortion listed in the Constitution, and some people argue that's the reason there shouldn't be abortions. On the other hand, there is this Amendment 9, which says, well, just because it's not listed here doesn't mean people don't have that right. And so the people who want the right to abortion can argue the other side. So another interesting part about this. And then lastly, Amendment 10, the powers not delegated to the United States, the federal government, by the Constitution, nor prohibited, are reserved for the states or the people. So if the Constitution doesn't talk about a specific type of crime or a specific type of procedure, then that purview, that the laws about that go back to the states, or if not the states, to the people, because the people always have the right to do whatever they want. So for example, marriage laws are state laws. You need to be certain age to get married in this state, another age to get married in another state, because the Constitution doesn't talk about marriage. Or driver's licenses, right? You can drive at a certain age in one state, and you need to be at a different age in another state, again, because the Constitution doesn't talk about driving. So that's preserved for the states. That's how the states get that authority. Okay, so there you have the Bill of Rights. What you need to do is choose, let's see, I see a bunch of people joined since we started. You have the Bill of Rights. What you need to do is choose any three of those civil rights. You can choose any three, for example, from the First Amendment, where you had all of those rights listed in that First Amendment. I'll just go there for a second. All of these. You could choose any three of these and write your essay about any of these: freedom of speech, freedom of religion, freedom of the press. That's just fine. Or you can shop through the different amendments and choose to write about gun control, about abortion, and anything else. Right, so it's up to you.
I'm sorry, you said pick three of one of those topics.
Basically pick three of one of these topics, yes, or any of the other topics in the other amendments. But sure, if you wrote about these three, that's all you need to do. Yeah.
Would it be okay to mix match them, like two from
Yes.
that one and then some
Yes.
of the amendments? Okay, perfect. Thank you.
Right about, that's right. You can take a piece of Amendment 4 and a piece of Amendment 5 and a piece of Amendment 1 and write about those three things. And I only say three things because you need to get to the 500 or 600 words in the 5 paragraphs. You can usually do that if you have three. But if there's a topic that's really of interest to you and you can say enough about it, you could just focus on that one topic. That's all right as well. In the first essay, I really was very strict about, you got to write about the right to life, the right to liberty, the pursuit of happiness. But here, I'm giving you a lot more freedom to choose what you want to write about. If you want to concentrate your thoughts, If you just want to write about gun control, if you just want to write about abortion, that's okay. Just do it in the context of the Bill of Rights. And then in the third essay, you'll have even more choice because it's much more wide open. Okay, let me stop right there and see if there are any other questions about what you need to do.
Hi, Professor. I have a question. So looking over the content where you have the syllabus posted, you had said that the second essay needed to be a compare and contrast form. Is that what we're leading to or not?
You don't really have to do that in that fashion. You just need to choose three different rights, and that's sufficient because you're
Okay.
focusing on three different things.
So it's most likely like almost the same that we did before.
Yes, it's just like what you did before. Yes, it's just like what you did before. For the second essay, you definitely need two outside sources in addition to the Bill of Rights itself.
Okay,
So you need
thank
to do
you.
a little more research. Yeah.
Hi, Professor. It still has to be third person as well.
Yes, definitely. Third person is our formal voice. It's the voice of truth and fact, and definitely you're writing in the third person. So if you want to say, I think abortion is a bad thing, just say abortion is a bad thing. Leave the I think out.
Okay, thank you.
Anybody else? Just checking here to see who's here and who's not. Okay, any other issues, questions, concerns? Thing that you want to write about? I see a couple of students came a little late and just want to repeat that there are a few of you who have not yet given me that first draft of the first essay, and you really shouldn't fall too far behind. There's still time. I'm just doing two things at once here. There's still time to catch up and finish that first essay and then move ahead with the second essay. But after a while, you won't have time to do that. Let me just bring up the curriculum just real quickly, just so I can show everybody that one more time. So you see how tight the term really winds up being. I know we just started, but finishing is right around the corner. Okay, that's this one. All right. So put this one down. Here's the curriculum. I know you can see it. And I'm just scrolling down here to the class schedule. And here we are on the 19th. We're looking at the second essay. And I'm asking for the first draft of that second essay to come on Tuesday. Today is Thursday. And then the second draft of that essay is going to be due on Thursday. So it's a week turnaround for two drafts. And then we're going to take it to next Tuesday. We're going to start already on the third essay, and that's the last day of January. And the turnaround is tight for that because here on February 7th, you need to be finished with that third essay and starting the final exam. And then everything's done here, February 14th. So we really only have 2 weeks in February, and it's already getting towards the end of January. So I just want to point that out. There's still some wiggle room. If you're a little late with the essay, okay, you need to do the essays. If I don't get anything back from you, I can't help you to improve. So please, if you haven't handed in anything, hand it in as soon as you can, even if it's not finished. And I'll give you some feedback, and that'll help you to do a second draft. And of course, everybody else get to work on your second essay. Okay, any other questions?
Can the second essay be submitted before Tuesday? The first draft?
Just, you have to repeat that, sorry. Just say it again.
The second essay, the first draft, can it be submitted before Tuesday?
Yes, absolutely. You can submit as soon as you want. Better for me. It spreads it out for me, and I can do a better job, responding to everybody. So sure, it's okay with me if they trickle in like that. If you have it done tomorrow, by all means, send it in.
Okay.
Okay, that's just great. Yes, so some of you are more comfortable doing this than others. And those, I have to say it one more time. If you haven't given me an essay, you need to do that. Okay, I won't say it again. All right. Anything else on anybody's mind?
Yes, do we lose points if we're below the word count?
It's not that the essays need to be at least 500 words. So in essence, yes, you would lose points. I don't actually use the point system, as you all can see, judging the whole of your writing. But you need to be able to write 500 words, and moving to the second essay, 600 words. And certainly the third essay should be 600 words, and the final should be 600 words. So you need those words. And part of the process here is doing a little bit of that research and finding the examples and coming up with the concepts that you're thinking about. So pushing you to write more words means that you have to do a little bit more work. Please do. And
One last thing, sorry. About the format of this one from the previous essay that we did, there was this like firstly, secondly, thirdly. Do we have to like also do the same thing? That way it'll be more clear for the readers to read it or something?
so that emphatic order was really just a suggestion to make it clear for the reader. You don't have to do that. You can use any kind of transition you want move from one idea to the next. Perhaps you're writing, you might say in your introduction, you might say there are three critical ideas in the, I'm making this up, three critical ideas in the Bill of Rights. And the first, you might write about freedom of speech, and then about gun control, and then about abortion, but you need to connect those in some way. The emphatic order just gives you an easy way to connect them, but there are lots of ways to do
Okay,
it.
so it doesn't necessarily means that we have to like if we have to do like 3 to 4 paragraphs, as long as it's like
Sure, that's also true. You gotta have at least 4 paragraphs, an introduction.
okay.
So
Okay.
sure, if you're writing about 2 topics and you have a lot to say, that's okay.
Okay, thank you.
I mean, the whole idea here is for you to be able to take a topic and write about it intelligently and present it in a formal way, so that it's respected and understood, and you communicate your ideas. So that's the important part of this, right? The other stuff, just suggestions to get you there. Okay, anybody else with any questions, concerns?
Mr. Felix,
I see you there. Yeah,
I'm working on it. I'm sending it to you this weekend. I'm working on it.
okay. As I said, the term starts to disappear really quickly, so don't wait too long.
I know time moving fast. I see that.
Okay,
It's moving.
okay, very good, very good.
All right.
Anybody else? Okay, so get to work. Have a good weekend. I'll see you next week.
Thank you. Bye.
Thank you,
Have a good
Professor.
Have a good weekend.
Bye-bye.
Thank you so much.